All right, so this is Jason Valentine with Coldwell Banker High Desert Realty. I wanted to thank you for joining me. Today, I am going to go over the residential management agreement. And this is just a great thing for our property owners to really kind of be informed about. So I'm sending you this video because most people don't take the time to read all of these little tidbits and such like that in the agreement. So I just want to go over by paragraph what is going on in these management agreements. So that way you as a property owner are a little more aware of what your obligations are and what the brokerage's obligations are. You know, one of the biggest misconceptions in property management is, you know, us as property managers are really kind of there as referees between the owner and the tenant to make sure that everybody's adhering towards laws, rules, regulations, and such. And then we also act on behalf of the owner to get things fixed and repaired, collect rents, file legal action when rents are not being collected, when people are running late and stuff like that. So anyway, this little I think it'll probably be about a 10-minute little video is just going to go over piece by piece kind of what is in these management agreements, so that way you as a property owner know kind of what's going on. So first off, I want to let you know we have broker duties in the state of New Mexico, and our broker duties include under section A here: honesty, reasonable care, professional conduct, compliance with local, state anti-discrimination laws, real estate licensing laws, and just rules and regulations of the state. Written disclosure of any potential conflicts of interest. If we do have a conflict of interest, we have an ownership in the property, or one of our family members is renting from you or whatever, we actually need to disclose that. And then any adverse material facts known about the property, we actually have to disclose to you and try to do so in writing. Section B, just so you know, a couple of things that are important in there is the big ones down here: consult with an attorney regarding validity or consequences of any written documents. That's something that's pretty important. You want to be sure that if you have questions, we are not attorneys. If you have questions about what's in these documents or taking action, on these documents, or not taking action on these documents, advise you to chat with an attorney so you're not getting yourself in trouble. The other big thing on paragraph 6 down there is, in a property management agreement, we are actually acting as an agent on behalf of the homeowner. And what that means is that we can actually take action on deciding who we're putting in on that property, what we're collecting on rent within the scope of authority and such. You'll see that at the end of this agreement, what the scope of authority is, et cetera. So we're actually acting as an agent in place of the owner. So there are certain things that we're going to have a written agreement on that you give us permission to do, and that's what we have to perform under. So I want to let you guys know a couple of other things on brokerage relationships. We do have a couple of other parties in here. If we do have other parties in here, like a family member is renting from you, or if you're going to use a particular company, LVH Investments, we have a relationship with those guys. So we're just disclosing to you, what's going on up there. This is actually the first page of the agreement, and the parties are the owner, and the brokerage is Coldwell Banker High Desert Realty. You're not hiring Jason Valentine to manage your property. You're hiring Coldwell Banker High Desert Realty. The relationship is just letting you know that, you're giving us the authority to act on your behalf to be able to keep the property rented as much as possible. The property address, that's pretty straightforward. Now the term, paragraph 4 down here, I want to let you guys know that the term is typically we write these management agreements for at least 2 years. And unless written notice of termination is given no later than 60 days is what we normally run prior to the end of the term, the term becomes a month-to-month agreement, and you need to give us 60 days to be able to terminate. Now, let me explain. Now, as I'm recording this video, it's the 10th of the month. Everything in property management works in terms or periods. The period begins on the 1st of the month. It ends on the last day of the month, whether it's the 30th or 31st. So if somebody, for example, gives a notice on the 10th of the month, that actually goes into effect for the first of the month. So then it would be 60 days from that period the term of this agreement. Same thing goes on tenants. Usually they're on a 30-day term. And so just be aware that the terms are what gets, you can't make a change in between the term or while you're in the middle of a term. The broker obligations and the grant of authority. Now, just so you're aware, paragraph 5, advertising, I typically don't charge any advertising fees to my property owners while we are trying to market and solicit property. My thought is that that's one of the services you're paying us for. And so consequently, we typically don't charge you anything for advertising fees. Due diligence, we do, scan or screen potential tenants to get into the properties. We ask for background checks and credit reports. We also ask for debt to income ratio. So we look for, how much money they're making. Obviously, if somebody's making $2,000 a month and you're putting them in a $1,500 a month rental, they're probably not going to be there for very long. So just be aware that we are going to do our due diligence. We have a process to go through on that. Let's see, lease agreements. You do allow us to enter into lease agreements on behalf of you as the owner, addressing tenant concerns. We do collect a 1 full month's deposit, typically in advance, before letting a tenant occupy the property. Paragraph F there, we maintain the property as close as we can to its existing condition, which means if there's repair work or whatever the case may be, if you look at paragraph F down there at the very bottom, it says broker may negotiate contracts for non-recurring items up to, typically that's $300 on our standard residential units. So that means if a repair is up to $300, that you are giving us authority to be able to act on your behalf without even calling you or telling you about it, short of getting your statements in the mail. So just understand that if it's $300.01, we're going to call you to get your authorization on something. But generally, we can get a lot of things done for less than $300 just to maintain the property for you. Paragraph G, if we do have to evict a tenant, we will evict the tenant, but we're not actually obligated to pursue legal civil action against them for any balances that are due and stuff like that. Usually we get the eviction and we get the judgments, and then it's up to you, the property owner, to do writs of restitution and such like that. Utilities, we will get the utilities not in Coldwell Banker's name, but what they are is actually they revert back to us. This is why we ask for owner deposits, because if you have a vacancy, let's say for a month on your property, we don't want to turn on and turn off the gas, for example. That costs very much. And also if you're in the winter months, that can be really, then you start having pipes freeze and such like that. So the reason we asked for permission to be able to get the utilities on is so that way we can just keep the property safe while it's not vacant. Commingling of funds, I'll let you know, I generally don't do commingling of funds. I try to keep everybody's property ledgers, or not try to, we do keep everybody's property ledgers straight and narrow. So even if you have multiple properties with us, and let's say property A has an expense that's bigger than what's in the property A's account, I'm going to call you and ask you for a separate check on that. I'm not going to take property A and property B and try to merge the two together. Vacation rentals, we don't do the short-term vacation rentals, so we don't have to hit that. Our additional responsibilities, just to let you know, is we do maintain records for 6 years. We do provide documentation, including residential rental agreements, applications, background checks, and such to our tenants upon request. We do collect deposits, and we hold those in a non-interest bearing trust account. And that way, if a tenant ever stiffs you on rent or whatever the case may be, we actually have a little bit of recourse to hold them accountable. We do provide you monthly accounting statements. That includes your what are called owner statements. And so there's samples of those that we will send out to you, so that way you understand kind of what the rent comes in, any costs that are associated with it, and what your disbursement check is. Also, when there's a repair done on your property, we also include an invoice of what that repair was. Just that way you have good record keeping, and you can see that we're the work that we're doing. And it's not that there's money missing from your disbursement and you don't know what it goes into. Let's take a look here. Paragraph 8, you just represent that you're the owner of the property by signing this, and that you have the authority to engage somebody to be able to do property management for you. If there's easement issues or restrictions we need to know about, if its property is zoned for its intended use. Obviously, we don't want to be getting into trouble, putting people in a property that they shouldn't be in. Let's take a look. Compensation, our standard compensation on property management is 10% of the rent collected plus applicable gross receipts tax. Now, what I will let you guys know is, that most people, most of the property managers in the city are going to charge you like first and last month's rent, or half of the first and half of the last month's rent and all this other stuff when they turn over properties. My thought is that we should be partners and keep your properties rented as much as possible. So I don't make actually any sort of bonuses for getting people out of your property. A couple of other things. The gross receipts tax, just so you know, that's nothing different than sales tax that you pay on services that are rendered. Just like if you have a plumber come out to your house, they charge you the fee plus gross receipts tax. That's what the gross receipts tax number is. Let's see, fees that we actually retain as the brokerage. We retain late fees because we have to run people out there, post notices on doors, begin court filing action. Insufficient funds fees, I actually charge those directly to the tenant, and we retain those because of the fact that that hits my trust account, and I've got to keep that trust account balanced. Let's see, other fees like pet rent. We do typically keep pet rent, which is usually $25 per pet, and that's because we make a priority to focus a little bit more on the properties with pets and be sure the pets aren't tearing up the properties and such. Now, I will tell you that's there's also a pet fee, a $200 non-refundable pet fee that we charge the tenants, and that goes directly to the property owner. Insurance, we do ask the owners to carry insurance and liability insurance on the property as required by the state of New Mexico. That way, if there is ever somebody who's injured on the property, whatever, you're properly protected. Lead-based paint, just so you know, if the house is built before 1978, we need to get a lead-based paint addendum from you, just indicating if you have any knowledge of whether lead paint exists in the house or not. Compliance with laws, I want to let you guys know, even if you ask us to, we can't violate the law. We are beholden to making sure that things are done legally, morally, and professionally. Paragraph 14 down here is the initial deposit reserve for the owner. As I was mentioning earlier, typically on a normal residential property, we get $300. And again, what this is used for is, let's say your property is vacant for a month or two, as we're doing a turnover, and you have utilities on, we're going to pay the utilities out of that. So that way, it's there if we need it. We account for it every month and it stays in your account. That's where the property ledgers come in. The other thing that we use that for, let's say, for example, I need to initiate court action against somebody. We're going to take the money out of that initial reserve. Now, if we do use any money out of that initial reserve, one of the first things we want to do when we get a tenant back in there is replenish that reserve up to, like I said, on a standard unit, it's $300. So that way, you always have that money in there in case there's a short repair or a small repair or a electric that needs to be kept on during a vacancy or what have you. We also asked our owners to put smoke detectors in their properties. That way you have just protection. You don't want to be the owner who took the shortcut on the smoke detector and then a tenant perished in your house. So we're just trying to do the right things as property. Tenants deposit refunds, we do hold the tenant deposits in a trust account at the brokerage level. So that way our owners don't have to worry about that stuff. Let's take a look down here on 18, paragraph 18. We typically don't allow our agreements to be assigned. That's just where you assign, you let somebody else take over the terms of this agreement and such like that. Let's see, the hold harmless clause. This is just letting you know that, let's say, for example, somebody slips on, we're out showing your property, trying to get it rented. There's ice on the front door and somebody slips and hurts themselves on the ice. You're not going to come back and try to say, well, Caldwell Banker, you guys were showing the property when that guy slipped on the ice. You're not going to try to come after us for something silly like that. Let's mediation, just to let you know, I am a realtor, so we subscribe to mediation. So that just means if there's a dispute, we try to sit down and talk it out. Let's take a look. Consent to do electronic signatures. That's always a nice little thing, just being able to do things via internet and get the signature signed on the internet. And then if there's any additional terms for your specific property, we just write them down in paragraph 29 right there. So really, that is the summary of the management agreement. Now, what we've got back here is kind of this what's called the scope of authority. Okay. And what this is basically saying under what pretenses can we rent your property out. So for example, the leases down here, prospective tenant leases, this gives us a minimum dollar amount and a maximum dollar amount that we can rent your property out. So let's say, for example, you gave us between $1,000 and $1,200 was the minimum and maximum amounts we can rent your property out for. We cannot, without your permission, rent it for less than $1,000 or for over $1,200. And so we want to keep these updated from time to time because rents do gradually increase, and we want to make sure that you're getting the very best return on your property. We also have the acceptable lease terms. Sometimes owners want shorter leases, 6 months. Sometimes they're okay doing leases up to 24 months. So this is just telling us what the minimum maximum time that we can put somebody into your property is. And then acceptable renewal terms, same type of thing, whether it's 6 months, whether it's 1 year, what have you. Water source, this is just letting us know that it's either on city water or well. Liquid waste, how we get rid of all the bad water in the house. The preferred number of occupants, just to let you know, we are beholden by HUD regulations on some of these things for the number of occupants that we can put into a property. For example, kids over the age of 8 years old you can't have a male and a female in the same room. So those are things that we just have to adhere to according to regulations. This is a big one. Will pets be considered? If the answer is no, that means no pets can be considered. However, service animals have to be treated like human beings and not like pets. So that means if somebody does have a service dog, let's say a blind person has a seeing eye dog, we actually have to treat that dog like a human being. So that doesn't qualify for pet fees and pet rent and stuff like that, just to be aware. The security deposit, we are typically collecting 1 month's rent as a security deposit that we hold in a trust account, just in case anybody skips on rent or what have you. I typically don't ask for prepaid rent. This is the next paragraph. We're talking about last month's rent and prepaid rent. I don't typically ask for prepaid rent because we want to try to keep renters are getting rentals for a reason. They typically don't have a whole bunch of money. So by the time we hit them for a first month's rent and a security deposit, they're actually paying what's equivalent to 2 months rent. So I typically don't get last month's rent from individuals. Down here on the insurance company stuff, we do want to get a copy of the insurance policy you have on your house and who the provider is. So that way, if there's an insurance issue, we can reach out to that provider and get things started, sometimes even before we call the owner. And that way you just know that you have somebody locally who's working to try to get your house taken care of if there's an insurance issue. We don't always require tenants to have renters insurance. That is something we leave that up to the tenant themselves. We do encourage them to get renters insurance. However, there's no guarantee. Just so you know, as a property owner, you should at least be carrying, I think they call it a fire policy on your house. That's going to cover in case there's vandalism or acts of God, they call it, where there's, a fire or lightning strikes the house or something like that. Tenants insurance policies typically only cover tenants' private property that might be in their house, their TVs and their furniture and stuff like that. Medical marijuana, I just want to let you guys know, medical marijuana is becoming a sticky situation in New Mexico because we're kind of in limbo right now where they've approved marijuana for recreational use, but nobody's really approved to recreationally use it yet. So just right now, we're probably going to try to stay away from any marijuana usage in the house because it is still a federal law. And so you can get into some sort of trouble if let's say a raid happens on the house and the feds seize your house as part of like the what would they call it, evidence or something like that. So we just don't even want to try to go down that path with you. So it's kind of a slick situation right now in New Mexico. And so we're going to try to stay away from it. So anyway, guys, that is what's called our scope of authority right there. That kind of gives us the terms under which we can rent to somebody. So this little video was just to give you an idea of what was going on with that management agreement. And, if you have any further questions or whatever, you can shoot us an email. But this is always a nice little introduction into it, because very few people actually read through that entire thing. All right. So, guys, this is Jason with Caldwell Banker, High Desert Realty. I appreciate your time. Thank you so much. Bye-bye.